higher and better offers or structures in the interests of stakeholders. And if that is the representation and the agreement, then I do think we are in agreement on those points.
Your Honor, I think it makes sense for Mr. Allett maybe to opine, and then I should respond.
Yes, Your Honor. For the record, Kenneth Allett, Brown Rudnick. Your Honor, nothing in the settlement agreement, in our view, forecloses any of the kinds of structures that the ad hoc group has privately proposed to the debtors or the committee. It's about customer claim treatment. Nothing in the agreement says that we must fund the cases by the DIP. If the ad hoc group comes in with a check, we are more than happy to take their check. We are more than happy to maximize value in every way. This is about how customers will be treated. And to confirm, again, nothing in this limits the ability of any person to object to a plan, to vote against a plan, or, sidesteps in any way the obligations that the debtors will have to meet all of the standards of the bankruptcy code.
All right.
And to confirm.
With that, Your Honor, thank you. With that, I think we are in agreement that the debtors and certainly the committee are happy to sit down with the ad hoc group and hear what it is they propose, and understand if it's a better deal. If it, one of the things they highlighted, they're hoping to fill the 5% gap that we think is going to cost customers to run this case, and if they can help us fill that gap and save customers money, hallelujah. Certainly, Your Honor, we're ready to go. So with that, I would add some other comments, Your Honor, about the 9019, but I think that resolves the objection of the ad hoc group.
Your Honor, Colin West of White & Case, I think there's one additional point that hasn't been addressed. One of the grounds for our objection was the announcement in the motion to approve the settlement that there was going to be this hierarchy of cost allocation, and the first cost would be first allocated to the reserved securities, which would be liquidated. And in our discussions just prior to the hearing, I think the representation that we received was that we, the ad hoc group, are free to object to each proposed liquidation, and in connection with those, any objection we might make, we could still object not only to the liquidation, but to the hierarchy of cost allocation that was announced in the motion. I don't believe it's actually in the term sheet or the stipulation, but it is in the motion. And I just wanted to make sure that the debtors are in agreement that all of our rights are reserved there. And if they are, then I do agree that we are resolved.
Your Honor, first, the court may recall we have the sales procedures motion and order that the court approved. All 2002 notice parties received notice of any proposed sale. The ad hoc committee can certainly object in that form or fashion. Nothing limits their rights. Then, Your Honor, in terms of how the funds are used, they're actually, assuming the DIP is approved, they are collateral for Santon, the proposed DIP financier or the interim DIP financier. So, subject to Santon's rights, which is where that collateral would go to start, Your Honor. Nothing in the settlement is meant to impair the rights of the ad hoc group or any other party to object to a sale of any reserved securities.
And, Your Honor, for the committee, we agree. I just don't quite understand what the possible objection to using unencumbered cash for the costs of the estate, for the cost of this case could be. I certainly agree that anybody can lodge whatever objection they want to lodge to that. I just don't see what it could be.
Mr. Brody, you had your hand up.
Your Honor, again, Josh Brody, Cleary Golly, on behalf of the Swagger Party. I think for efficiency's sake, Your Honor, the issues we had raised in our reservation of rights were very similar, and it sounds like they've been resolved based on all the comments of counsel. I just thought I'd get that out of the way.
All right. All right. Who else wishes to be heard with respect to the 9019 motion?
Your Honor, Stephen Reisman, Catton Special Counsel to the debtors at the sole direction of the special subcommittee of the board comprised of Jeremy Rosenthal, Allison Cutler, and Norman Reed, and Mr. Stein, the debtor's CRO, as a non-voting member. I was hoping not to speak, but I just want to make it clear for the record. The special subcommittee, the board, directors, independent directors are all well aware of their fiduciary duties. Nothing in this settlement is intended in any way to waive the director's fiduciary duties to maximize value for the benefit of all creditors, stakeholders, interest holders here in that regard. And we will explore and consider any and all alternatives as things move forward. But as present right now, this settlement is, or this proposed 1919 is in the best interest of the debtors. I think it meets the standard for approval, subject, of course, to including it into a plan and some of the details associated with that. But to the extent that an interest holder, third party, or anybody comes forward with something that provides a greater recovery, a more sure recovery, a more solid foundation, even though this is a very solid foundation on which to build a skyscraper, the board is not in any way intending to waive that fiduciary obligation, nor did it previously in that regard. I just want that to be clear for the record as we move forward with our work and the debtors move forward towards the plan here. Thank you.
All right. Anyone else wish to be heard? All right. Mr. Solomon, wish to be heard?
Yes, Your Honor. Can you hear me?
I can hear you.
Thank you very much. Look, I just wanted to put on the record the fact that Mr. Schwartz believes the directors owe no fiduciary duty to shareholders. So I want it very clear when the statements were just made by the debtors, do interested parties include shareholders?
I think fiduciary duties are to everybody here, to the debtors as a whole, creditors, interest holders. If there's a way to get a recovery for the benefit of interest holders here, for the benefit of equity, right, that is an obligation of all fiduciaries of this estate, and we take that obligation seriously.
And I think, Your Honor,
just on the record, you've actually denied that in writing. But could you mention the word shareholders so we're very clear?
So, Your Honor, Mr. Solomon's directing those comments at me. Certainly the debtors agree and believe that the fiduciary duties of officers and directors in an insolvency, like this case, expand to the creditors, and then you run into the absolute priority rule and who comes first. So I think inadvertently Mr. Solomon is misconstruing something that I wrote to him when he was reaching out to the directors and asking them to take steps that were in the best interest of the shareholders in a way that I thought was detrimental to the creditors and parties in interest that come ahead of shareholders. So with that, nobody's disavowing any of their fiduciary duties or obligations. And with that as a backdrop, Mr. Solomon should have some comfort that we are working with the ad hoc committee to try and find recovery for equity holders if there is one, however unlikely that may be.
All right. Mr. Kelsey.
Thank you. Thank you, Your Honor. I'll be very brief. It sounds like most of our concerns were addressed, but just briefly, Ripple is in a unique position here in that we're involved in this case because some of our shareholders that sold securities do link to, and while we appreciate that there'll be a plan process and that will be heard, we just wanted to make sure that this settlement did not foreclose our ability to make arguments in the plan relative to treatment of our share, particularly in the publicly traded closed-end fund. So as long as our rights, to speak with people about structuring the plan as it relates to our securities and making sure that the plan complies with our bylaws, we're happy to let the settlement proceed.
All right, Mr. Cunningham, did you wish to say something?
Yes, Your Honor. Thank you so much for the time. I'll be very brief. Your Honor, I was one of the very first customers in the early days of 2020 as a client on the Link2 platform. I'm the number one owner of Ripple SPVs on the platform. And, Your Honor, I'd just like to read into the record for my benefit and for your consideration that the only agency in the United States tasked with the responsibility of investor protection is the Securities and Exchange Commission. Your Honor, we have not heard anything whatsoever from the SEC. We have not heard an opinion, much less a ruling on probably the most germane topic as to whether we, Your Honor, are equity owners or creditors. That has just been a determination made out of whole cloth by one party in this case. And, Your Honor, I respectfully reject the claim that I am a creditor or any of the other 15,000 customers are creditors. We have equity rights and property rights, and we have not even heard the SEC give an opinion as to whether we should be classified, Your Honor, as creditors. Secondly, my understanding is that every hand raised equity held on the Link2 platform has an agreement that includes a right of first refusal among all of the companies that are on the platform. And if those companies choose to not allow a transfer of their stock into a closed-end fund, then we as clients run the risk of losing or having to sell all of our property at a price, whether we want to or not. This risk has not been disclosed to us. At an absolute minimum, before any proposal was put on the table to vote on a closed-end fund or a liquidation trust, we weren't even given the opportunity to have the SEC make an opinion or disclose that a company like Ripple could exercise their right of first refusal, buy all the stock, and we lose all of our stock at a price that we didn't want to. So, Your Honor, given the fact that we're supposed to take hearsay solace in one party deeming us to be creditors instead of equity owners with property rights, and the SEC not reading into this at all, and the SEC being closed down with a government shutdown, Your Honor, my respectful request is that we pause. There is no sense of urgency to move forward. We as clients don't trade SPVs on a weekly, monthly, quarterly, or annual basis. We buy once, and then they're transferred once at a liquidity event. There is no sense of urgency from my perspective, Your Honor, that we have to rush to make a decision to come up with an agreement that 15,000 clients around the world in 130 nations are completely unaware of all the details and the lack of contextual nuance. That's my request, Honor, is that we at least, at a minimum, agree from a fiduciary standpoint that we let the SEC be heard from an opinion standpoint as to whether we're creditors or equity owners. Thank you, Your Honor.
All right, thank you. So, a couple of things. Number one, I think you need to view the 9019 settlement as really the framework and the interim steps that the debtor and the committee intend to take in order to try to see if a plan can be confirmed. I mean, the plan is going to be, there's going to be a disclosure statement on full notice. There's going to be a plan that will provide all of the, I have to make a determination that there's adequate information. That's not before me today. The only thing that's in front of me today is the framework for what the the committee and the debtor are working towards to provide the interested parties, and I'll call them interested parties, the maximum recovery possible. With respect to the SEC, Mr. Cunningham, I'm the person who makes the decision as to whether you have a claim or you're an interest holder and what you're an interest holder in. That is, again, not before me. I just recently had to issue a very lengthy opinion in connection with an instrument called a SAFE to determine whether it was debt or equity. And so that issue will come before me. Obviously, to the extent that you're a creditor, your claim is determined on the day that the case was filed, and it's limited to that under 502B. And obviously, I suspect that somebody will raise that at the confirmation, and that's something that, unless it's resolved, I will have to address. But I don't think that the debtor is putting the cart before the horse. I think that the debtor is exercising its obligation to, try to get to an acceptable solution. And I will, and I think Mr. Schwartz has been very, very clear about this. At the end of the day, no one's going to be happy. No one is going to be happy. They're going to try to make the best of a bad situation, and I think that Mr. Schwartz, working with the committee, are doing a very good job of really trying to do the best they can with the cards that they've been dealt. So I don't think that we're in a situation where the cart is being put before the horse, and obviously there will be due process, and there will be the ability to be heard and protections all along the way. Anyone else wish to be heard?
Yes, Your Honor.
Yes.
Yes. Again, this is Ron Davis, and I had I think you kind of asked, and it was asked and answered. I think it was muted. But being a sophisticated retail investor, I understand that the legislation that is being looked at for the accredited investor and the re-establishing that. But you said you have binding. Your verdict is going to be binding with people being accredited or unaccredited or equity up inside of these SPVs as for the ownership. And so if the SEC, can I finish, please? So if the SEC changed the rules, because this is a bill that's up in legislations right now, would we be godfathered in, or who would that fall under whose jurisdiction at that particular time? Because you did mention that something may be in front of you, or that question is not in front of you at this time, but it may in the near future. Am I correct?
Partially correct. What I said was that in connection with this bankruptcy case, I'm the person who determines whether you are a creditor or a shareholder.
Okay.
Under 502. As it relates to whether you're an accredited investor or not an accredited investor, that isn't anything that I address. I only address the issue of whether you're a creditor or an interest holder in the bankruptcy context for purposes of a recovery.
Okay.
All right. Anyone else wish to be heard? All right.
Good morning, Your Honor. This is John Murray.
Yes,
I raised my hand and go to meeting.
Go ahead.
Just very, very briefly, thank you for your work helping us through this, and thank you to your staff for working during the federal shutdown. I'd like to draw the court's attention to docket number 671, which was filed by Mr. Pease and the ad hoc committee. In that document, the proposal for introducing new capitalization, external funding coming in to help the company work through this process is is drawn attention to in that filing. In my experience, successful startups, when they encounter business challenges, would typically go to the investor community to raise additional funds from investors, including myself. This is a normal way that things work with startups, as I say, in my experience, and I would strongly urge the court to pay attention to these sorts of recapitalization approaches, such as the one that is presented in docket 761. Thank you.
Thank you. All right. Anyone else wish to be heard?
Your Honor, this is Barry Spencer, Alpharetta, Georgia. I appreciate your time, and my only comment is I'm not an attorney, and my only comment in the proceedings of 9019 is that there would be any issue that would be beneficial for all interested parties, including us as SPV shareholders.
Yes, it's me again, the real quick informant, X-Rated Pennies, sitting here with the Link 2 conference. If you are XRP holder or a holder in equities and Ripple, Uphold, Gronk, SpaceX, these are, they filed, Link 2 filed for bankruptcy, and they're doing a bankruptcy hearing, and they're trying to determine if certain people are accredited or some people are unaccredited. Do they have an interest or are they actually shareholders? And so they're trying to, the committee and the judge are trying to come together and have a settlement. And the question that I was asking was, seeing that the SEC is taking a look at their accredited investor status, is that would we be godfathered in, or would we be still considered just interest and not actually have other shares? So that was the question I was asked, and it was asked and answered. But for right now, at the particular time that this was filed, whatever status you were under at that particular time, then that's where you're at. And they said, but he hasn't made an actual ruling on that yet.
398 million as of the snapshot date of June 30th. Well, it's interesting because in the public domain, there's information that identifies Link 2 owns a total of 4.7 million shares. And then within that week of the snapshot, Ripple executes a buyback or tender offer at a $175 per share price. So that would mean the total value for Ripple shares alone would be north of $800 million, which is a $500 million discrepancy of what's being stated on docket or document 533. Another discrepancy also shows that Link 2 is zeroed out at zero equity. Being a shareholder, the fair market value, according to the custodian, is 49 cents per share. So I don't know why there's a discrepancy there. Chime also went public. Another discrepancy on 533 is Chime went public on, I believe, June 12th. Let me be specific here. And regardless, though, it's not being reflected in the public equity section as it is being reflected in the latter of the pages of the document. So it seems like there's some discrepancies on what potentially the total values we're discussing. I don't see that being discussed.
Yeah, and that isn't, we're not dealing with anything having to do with that. We're strictly dealing with the 9019, which is, in essence, what is going to be proposed. There's nothing that is being actually done today.
Okay, but if we're talking about a solution and that total dollar value is really, if it's only 685 million, and that's the end solution, shouldn't we be rethinking some of these numbers if there's public data pointing to higher figures?
I suspect that the ad hoc equity group will raise that. That's one of the items that they raised, that evaluation of the Link 2 of the Ripple shares were, just doing the math, was 800 million.
Perfect. Excellent. Just wanted to bring that up. Thank you, sir. Thank you.
Your Honor, if I may say for some debtors, I need to address that a little bit because the number of people listening to the call and Mr. Fuentes routinely is broadcasting his views and opinions about the case, often linking himself to anything that Mr. Deaton does, which then sends his views out to several thousand people in the case. Happening a lot, Your Honor, and it's creating some upheaval based on misinformation, including something you just heard about people being grandfathered in. comes from a video that Mr. Fuentes posted recently. So that concept. With that, Your Honor, so the court's aware, and so the parties listening are aware, the values that were put in the schedules upon filing reflect the dollars invested or paid by customers as of the petition date. That's the roughly $400 million number that's there. Just yesterday, we amended Schedule E, Ask Docket 700, as part of the settlement with the committee to reflect that customer accounts now show the purported economic interests, or the Schedule EF shows the purported economic interest that the customers would have held with respect to Link 2 and Liquid shares had the SPVs and the balance of other entities been set up properly. So we believe the fair market value numbers that Mr. Fuentes just was highlighting are now absorbed by the amendments to Schedule EF. So the values that he just put forward are no longer the way the debtors are calculating customer claims. Again, as part of our settlement, if approved today. And so I believe the concerns that were just raised have been resolved.
Okay.
All right. Anything further from anyone? Anyone else wish to be heard?
He shut that shit down.
Yes, Your Honor. Rob Cunningham again, if you don't mind, sir. Just to opine on Mr. Spencer's commentary about alternative solutions for recapitalization. Your Honor, I would respectfully request the UCC and all parties concerned, if there is a plausible business model of recapitalization of Link 2 in the form where 100% of SPV values at current market today or 6 months from now or a year from now is actually doable. And it is, if there is a reconstitution plan, we should take the time to evaluate them. What I'm hearing, Your Honor, is an assumption and a presumption that Link to the entity itself is dead. It cannot be reconstituted. It's unsalvageable. And that determination has not been made by the SEC. It's not, in fact, an unsalvageable company. Problems can be fixed through compliance and regulation and penalties and fines. And if there are investors that want to come in and honor 100% of the spirit and intent of SPVs, recapitalize the company and grow it so that we all prosper, Your Honor, I would respectfully request that we take just a pause before we rush into a decision on something where all of our options that provide maximum equity value for all parties isn't given a fair hearing.
Your Honor, I think it's been raised enough that I think it'd be helpful for the committee to respond quickly.
Yes,
every day costs customers money. And in every case, Chapter 11 case, it's very common people come out of the woodwork with ideas, but no money. If somebody comes in with a checkbook, the UCC will absolutely hear them out. The UCC is composed of mostly customers who are looking at paying that 5%, and none of them are happy about it. As I said at the last hearing, they're furious. But spending 3 months wasting time on something that ultimately doesn't pan out makes that 5% go up. So if somebody is going to come in and write a big, big check, it's going to be 8 figures or more. The UCC will absolutely grab at that check. But I need to be clear that I've seen proposals that are being passed around that are utterly fraudulent. And I'm not including the ad hoc groups in that, but I was passed one yesterday that was utterly fraudulent, that somebody, appears to have persuaded a customer that, hey, we've got a solution for you. This is going to make everything okay. Read it, and it was, well, they get 20% of the company and, money will appear out of thin air. Completely fraudulent. So if there is a way to get value for customers, the committee is absolutely going to grab it.
He said at least 8 figures.
What we're not interested in doing is gambling even more losses on something that won't pan out. So if somebody comes in with a checkbook, again, we're going to grab at it. But waiting a couple of months for these proposals, that's gambling with the money of customers to potentially get equity holders a return. And that is not something that the committee is interested in doing. Thank you, Your Honor.
Your Honor, if I may, the presumptions that Mr. Allu just referred to, disparaging, conclusive, and I say as a complete mischaracterization of some of the things that I have seen flown around. To be quite clear and transparent, Your Honor, I myself personally have agreed to pledge upwards of $100 million of assets to borrow against for recapitalization of a plan. That, Your Honor, is real money, that is real liquidity, and that would hire a real CEO, chief legal officer, chief compliance officer, and a team to right the ship, respect the ownership equity of every customer, and try to grow Link2 into a bigger, more vibrant company. So with all due respect to the previous speaker, Your Honor, there is liquidity, but no one's going to just write a check and then cross their fingers and hope that the verdict is cast in their favor. They would want to understand that a plan has been looked at, given the right to be voted upon, and upon vote, the capital can be made available. And Your Honor, I can promise you the capital can be made available, but Mr. Kenneth does not understand even kind of back channel conversations between people that are trying to put a reconstitution plan on the table. They just want to rush to a final settlement as quickly as possible, and 95% or 90% is the best we can do, period, full stop. I wholeheartedly disagree with this conclusion, Your Honor.
All right. Anyone else wish to be heard?
Your Honor, Gavin Solomon again.
Yes.
Sorry, for me, my apologies, Your Honor, and thank you for all your help in this.
Somebody said they got 100 million.
Points. The court needs to address that unit holders are not valid members of the UCC. Only creditors under the definition in Chapter 11 can be members of the UCC. So every unit holder who's a member who says they're a voting member of the UCC, therefore are creditors and are only entitled to their investment back with no upside. So I don't believe that the UCC members who are unit holders can vote. Secondly, under the plan, the litigation fund, shareholders have seen $700 million plus of value destroyed in the last 12 months. We've got the shareholders and the company have $700 million of claims that they can make against lawyers. The lawyers who did the SPAC, Lowenstein, Wilson Sonsini, the auditors who gave clean bills of health, operation of the SPVs, etc. So under the plan at the moment, we've got this massive conflict of creditors and directors being in control of the litigation fund so that the money can go to the estate, and the estate, of course, can go first to all the creditors. Secondly, unit holders as equity players can participate, and so should shareholders. But this board, the debtors are driven by destroying shareholder value and limiting shareholders and all stakeholder interests in the litigation fund because the directors have concerns as to how they've acted. For example, Link2 Texas was incorporated without approval of the board or the board committee. These are fundamental issues that need to be addressed before anything can be put before you, Your Honour. Thank you.
All right. Does anyone else have anything to say with respect to the 9019? Just the 9019. This is not a plan confirmation hearing. This is not a disclosure statement hearing. This is just the 9019, which, as I indicated before, provides the framework for the continuing discussions regarding a plan. So does anyone else wish to be heard?
Your Honor, this is John Deaton on behalf of the 3,800 customers of Link2 that I represent. I just want, for those listening, I was the first one to file an objection to the DIP, the first one to allege a constructive trust theory, and I've been working with the counsel for the creditors committee and the debtor, and on behalf of those 3,800 customers, we believe that moving forward with this framework is in the best interest. Thank you.
Thank you.
I do have a short reply, Your Honor, but I'll wait till the end.
Okay. Yeah, because. All right. Anyone else wish to be heard?
Dario Boriani in Orlando. Can you hear me?
Yes, I can hear you. I think I've unmuted everyone.
Thank you. Okay. I appreciate the opportunity. I speak for myself and 6 other accredited investors. We all purchased LLC membership interest in one or more SPVs. We have a pleading in docket number 678 on 9/26 of this year. We have a letter directed to Mr. Jesus Ancheta, the current manager of all SPVs. We copied counsels to the debtor and the committee. We haven't had a reply today. We basically believe that investors need to be properly represented by someone that will protect their interests. And we would like the court to consider our pleading in detail. We have quite a bit of material attached to that pleading that you may not have seen, and would add very useful insights to what's going on. But the main point is we would like an independent manager needed to be appointed so that they can really properly protect our interests of the investors. And that's all I have for now. Thank you very much.
All right, thank you. Anyone else wish to be heard? All right, Mr. Schwartz, briefly, and then I'm prepared to rule.
Thank you, Your Honor. I think a good deal of what's in front of you misconstrues the settlement in that, in fact, the deal that's in front of the court, all the objections overlook that it does what many of the parties are asking for, which is provide the customers with the value and the deal they understood they were getting when they came on board to this platform. It's the same is true for the equity holders who are raising these objections. That they sit where they sit under the absolute priority rule, and some of the issues we're dealing with, the supposition, the innuendo, the inappropriate shots at current management, and again, Your Honor, I have to remind you, this is a fraud case, and it's current management that blew the whistle on the fraud. And so all these other things that are out there, Your Honor, I think are all reasons to move this case forward, because all that's happening is supposition. The plan that Mr. That highlighted, I think, Your Honor, was written by ChatGPT. We're in a bit of a different environment now where somebody can ask AI to write a plan for it, and around it goes. And suddenly everybody thinks, holy cow, that looks like a real document with real people that are drafting things that might have money. The truth is, Your Honor, the only folks that have come to the table to put up money are our proposed DIP lender and the debtors, maybe the ad hoc committee, but we don't know how they're going to finance that. So I appreciate all the things that Mr. Cunningham is saying and all the stuff that he's saying he will put up. We have no evidence that he even has $1 million, much less $100 million, to come forward and refinance this case. So I think, Your Honor, with that, it's as important as Mr. Olet and the committee are highlighting. We need to move this case forward because the cost to sit back and wait just don't justify the juice, Your Honor, I think won't be worth the squeeze. And with that, I would ask that you approve the motion, Your Honor, and thank you for allowing me to finish.
Your Honor, if I may respond to Mr. Schwartz.
Yeah, just very, very briefly. I'm prepared to rule.
Yes, sir, Your Honor. There was no ChatGPT involved in any inference of what I spoke about. There is a gentleman that has been the chairman and CEO of a very successful company with $80 billion in customer assets and millions of customers around the world. Highly reputable, highly experienced, highly successful CEO. I don't need to provide my personal financial statements to Mr. Schwartz, and he's more than welcome to, I have $4 million on Link2 alone. As a capital standpoint, that's not anywhere near all of my assets. He has no idea what my net worth is. So to disparage whether the resources are available for a recapitalization plan is being stated only because he has a sense of urgency to get a ruling Your Honor, I'm just saying that there is virtue in patience. There is no reason for us to hurry. And the only reason equity would be destroyed is the lawyers would continue to run bills while we were waiting for SEC opinions and other reconstitution opportunities that might be better for the customers than what we're talking about today in this hearing.
All right. So I have I've reviewed the motion along with the clarifications that have been provided to address some of the ad hoc groups' concerns. I do find this a proper exercise of the debtor's business judgment. I think that this is going to be a difficult case. This is a fraud case, and all fraud cases are all difficult. And as a result, I believe that the debtor has exercised their business judgment, and that the debtor has met the requirements in the Fifth Circuit to have a settlement approved based on the legal factors. So on that basis, I'm going to go ahead and approve the settlement. So, Mr. Schwartz, is there a revised form of order that I should be looking at?
Your Honor, I don't believe, I think we've agreed the representations on the record would be sufficient, so the form of order that was proposed with the motion is the proper one to enter.
Okay, all right. I will go ahead and do that. So give me a minute.
Hey, he approved the motion. That shit Ron was talking about. He said, fuck that. That 100 million, all that there he talking about in theory. He said, man, they don't want to run the money and all that there. So they're gonna approve the motion. They're gonna give us some guidelines. And if you got some money involved in here, they're gonna make it give you a chance to decide if you want to get it through stocks or a closed trust fund.
Order and sent it to docketing. Unfortunately, we're going to need to recess this hearing till 2:30. So we'll come back at 2:30 for the other motions that are set for hearing at that time.
Thank you, Your Honor.
All right. So you are all
2:30.
excused. I'm going to take up my.
I'll be back at 2:30. We're going to smash, we're going to share, we're going to like. We know what you hold. Sophisticated retail investor, real crypto informant, X-rated penny, crypto jazz.
Thank you.
Know what you hold. Know what you hold. Know what you hold.
Conference recording stopped. Goodbye. Line muted.
Know what you hold. I'll holler back at y'all later at 2:30. It's my money and I want it now.
Welcome to Nathan Watkins meeting. Press 1 to join.
It's my money and I want it now.
Conference recording started.
All right, I'll get back at y'all in an hour and a half, man. Real Crypto Informant, X-Rated Pennies.